Ms. Lawal. We could not reach an agreement. And I believe, I wanted to confirm with the court, I believe this will be a judgment on the pleadings, but I believe there was a late answer, so I'm not sure.
Let me take a look. All right, Ms. Lawal, you can turn on your microphone.
Yes.
All right. So the answer was filed, it looks like, on 12/3. She was served by tech and mail on November 20th. Let's see. So the answer that I'm seeing says, I, Simisola Lawal, did not send the November payment for November due to the government shutdown that affected payment. This was beyond my control, and charges that I can't afford have been added to the account, which also affected my payment. I would like to explain further to the judge. Thank you. So that reads to me like it's an admission of non-payment. It also doesn't sound like there's a legal defense in there. The answer was filed on December 3rd. So, and there wasn't.
Today, we're watching how a case can quietly tilt before anyone realizes it. The judge reviews the timeline and immediately spots the issue, a late answer. On paper, this looks procedural, but procedure is power in court. The tenant's own written words are read aloud, and suddenly what felt like an explanation starts sounding like an admission. This is where many cases are lost, not on facts, but on how those facts are written.
Order for a late answer that was issued on the 8th. It said the defendant can seek a writ of possession. And there was a letter to the court saying she was out of town and she didn't get the letter until she got home. And then I think the judge asked for some travel documents. I think we got them. So Judge Guy set it for a hearing. It does look like the answer was late. So if we construe this as a late answer, and it was tack and mail, then no money judgment can be entered against her. However, if we're going to accept the answer, even though it's late, because she filed an answer, then a money judgment could be entered against her. So what's your position on this, Ms. Lewis?
Your Honor, I didn't see I think I saw the order stating that it wasn't late. I did not see that my position would be that it is a judgment on the pleadings. I would accept the answer.
Because this is where strategy meets consequence. The judge explains the trap clearly. If the late answer is accepted, a money judgment becomes possible. If it's rejected, it limits the landlord's options. The landlord's attorney doesn't hesitate. She wants judgment on the pleadings in a writ. This moment shows how lawyers use timing and wording to turn procedural choices into financial leverage.
And move forward with the money judgment and request the 7-day writ.
Okay. If there's no answer, then it would be a written stanter. Is that correct?
Actually, Your Honor, since she's here, I would be willing to give her the 7 days and just would not seek the monetary judgment in that instance.
Okay. Well, I think because Ms. Lawal, do you want to add anything? We're talking a lot about you, but not giving you a chance to say anything. So go ahead, and if you want to say something.
So this is my stance, Your Honor. I have tried severally to resolve the issue. I have taken my money to them. I'm willing and able to pay the brand amount that was due. I explained to them that due to the shutdown, our money was not dispensed to us. And as soon as it was dispensed, that day I went to the office. I said, hey, this is my money. Can I get relief on the late fee? They were like, no, we need all the late fee, all that. I'm like, right now, because of the whole.
Now the tenant finally speaks and emotion fills the room. She explains the government shutdown, delayed pay, and late fees piling up faster than she can breathe. She says she had the rent, begged for relief, and watched penalties snowball into nearly $1,000. It's a human story, but court isn't moved by hardship alone. This is the painful gap between fairness and legality.
Shutdown situation, it affected the days that we paid. They expected the money that we get paid. We only, as soon as my money was available, I brought it to you guys to make the payment. If you don't accept this payment, another late fee is going to go on top of it. And there's no way I'm going to go steal money or get more money from anywhere. So this now accrued more late fee onto the amount. Now I'm paying double the amount. My late fee is now almost over $1,000, and I'm still trying to resolve the situation with them. I'm like, hey, this is my money. I'm ready to pay. I have my money, even till.
So what does your lease say about the late fee?
I'm not sure exactly what it says verbatim. But I know that they were offering relief due to the shutdown, even different. I mean, I'm not sure, but I'll just follow the court's guidance on what to do at this point. All I want is just relief from my late fee, then I can pay a huge lump sum of the money today, right now, take it to them, and then have time to pay the rest. All I'm just begging and asking the court for is just relief from this late fee, because my next month rent is still coming up and I still have to pay that,
So unfortunately, my hands are a little bit tied, okay, because I'm required to follow the law. And Georgia law around contracts, which is what a lease is pretty strict. So
because the judge draws a hard legal line. Financial hardship, delayed pay, even national shutdowns. None of it counts as a legal defense under Georgia law. Without the lease in front of the court, the judge's hands are tied. The answer is officially treated as an admission, and the law requires judgment. This is where many tenants realize too late that honesty without legal framing can backfire.
Without a lease to look at here today, it's very difficult for me to say, I can't give you that relief of not having to pay the late fee. Okay. So kind of where we are right now procedurally is that your answer was late. The court accepted your late answer. So I'm going to go ahead and accept the late answer. Okay. The answer that you filed is basically an admission. You did not raise any defenses in your answer. Okay? So what Ms. Lewis is asking for is a judgment against you on the pleadings because you didn't raise a defense in your answer. And the law says that when no defense is raised in the answer, I have to issue a judgment against you. Okay. So I'm a little bit, my hands are a little bit tied as to what I can do. Ms. Lewis is saying that she's willing to give 7 days instead of a writ today. So unless you want to speak with Ms. Lewis again and see if you can work something else out, and I don't know if Ms. Lewis is willing to do that or not, and see if you can work out some kind of payment arrangement that would include those late fees. It sounds like she either doesn't have authority or is not willing to waive those late fees. Then I can enter a consent agreement, but otherwise I'm going to enter a judgment against you on the pleadings, give you 7 days to move, and enter a money judgment against you. But that judgment will mean that it does not mean that the landlord has to take any money from you. So if I say, I'm just pulling this number out of thin air, just as an example, if my judgment is for $5,000 against you, if you walk into the rental office with $5,000 and offer it to them and they say, no, they don't have to take it. Okay. If they do take it, then they cannot move forward with the eviction. Obviously, they apply it to your balance and whatever, but they cannot move forward with the eviction. But if they don't want to take it, they don't have to. Okay, that's what the law says. Does that make sense?
Yes. Well, Your Honor, can you clarify what you mean by defense? There was no defense on my response.
So you admitted in your answer that you did not pay rent for November. And you did not raise a legal defense under Georgia law.
I think, okay, so the legal defense, the shutdown is not part of the, it's not.
It's
Okay.
not a legal defense.
Okay.
So if at the beginning of the calendar today, when we started court, I gave a speech and I talked about if you admit that you owe money or you said you couldn't pay because you didn't have the money, those are not legal defenses. And I talked about other reasons, including the government shutdown.
This is the reality check that stuns people. The judge explains that even if the tenant offers full payment, the landlord can legally refuse it after judgment. That single statement changes everything. The courtroom pauses as the stakes become clear. Eviction can move forward even with money in hand. It's a harsh lesson in how eviction law prioritizes procedure over last-minute fixes.
Unfortunately, Georgia just does not have a defense for inability to pay or financial hardship. Okay.
I had the money, Your Honor. I had the money to pay at that time, but we were just disputing because of the timing of the dispensing of my pay.
Right, but that's not what your answer says. You just said you could not afford it.
Afford the late payment.
Correct.
That's what I said. I didn't put I could
That's
not.
what your answer said.
It just says I could not afford it, or I could not afford it. Well, I meant the late payment, not my rent. I had my rents to pay, and I can.
Right. It doesn't matter because technically under the law, when your rent is okay. Let me stop for a second. I can't give you legal advice. I would love to be able to help you in that way, but I cannot because I'm here as a judge, not as an attorney. So I cannot give you legal advice. Okay. So all I can say is that the way that I'm reading your answer, I do not read that there is a valid defense raised. Okay. You have every right to file a petition for review and dispute my decision if you would wish to do so. Okay. But for now, we're going to move forward on the judgment on the pleadings, unless you'd like another opportunity to speak with Ms. Lewis again and try to work it out.
Yeah, if she's open to it.
Because this ends with a narrow escape. After a brief negotiation, both sides reach a pay and stay agreement. A deadline, a lump sum, and strict consequences are laid out, and the tenant agrees on the record. Relief comes, but it's fragile and final. No appeal, no second chances. If this breakdown helped you understand how court really works, like the video, subscribe to the channel, and we'll see you in the next video.